Taylor? Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your...
Oh, this is my son, Brandon Taylor.
Uh-huh. Why'd you wear that this morning?
Because he's my entire world and he's missing me there.
Okay. Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have the printout paperwork that got all the information. They're extremely expensive. I've not been able to get the funds gathered for that.
Who'd you talk to?
I spoke to another gal
Where?
a month ago.
Where'd you...
Right in my phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. And I can get that turned into you after,
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text. See, Mr. Rojas, you have Christian Kane.
That's the one that is competent, but he bonded out. And you told me to set it.
Oh, okay.
But we've never had,
Yeah.
really had that yet.
And was ordered to
Yes, ma'am.
And he brought it up.
Yeah.
Christian Kane. Okay.
You mentioned spindle.
Are they here still? Good morning. Are you Christian Kane? So, Mr. Kane, I want to visit real quick before we go forward. We were here when you were in custody and had a doctor visit with you, and I made a finding that there needed to be some treatment for competency restoration, and then you've made bond. And so we've got to make sure that you understand everything. Are you currently under any treatment through Spindletop or any type of psychologist or anything like that?
No.
Okay.
Last I had from my own personal doctor was a Valium, which is a very low barbiturate, which is to help control severe anxiety. It's so low that it's 10 times weaker, I like to say, than clonopin, 10 times weaker than Xanax.
So let me explain something, Mr. Kane. Because we have a doctor's report that says that there needs to be held on.
See me, I waited for 2 months.
No, they did see you, and they already made the report, and I ordered that you go.
Why?
Well, because they're the doctors, I don't know. So, I'm sorry. What'd you just say?
My opinion, sorry.
I didn't hear your words.
They made a fool out of it.
That's what I thought I heard. So here's what I'm going to do, Mr. Kane, because I've got to make sure that you're safe, that everyone in the community is safe. And at this time, I'm going to revoke your bond and find that you are at large
Victorian
with,
and early graduate.
and so I'm going to, that we already have that order in place on that report, taking judicial notice of the court's file. You need to go back with the bailiff, sir. Ms. Taylor? Amphetamines and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions, and I'm going to raise your bond in your case to $100,000. Let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 at all time. Get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question? Okay, I have a child
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I.
Go back with the bailiff right now. More reading of the motion.
He will, yeah.
I didn't already have that, sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. You violated your probation and count one only by failing to act in a courteous and professional manner by incurring through the inmate on November 29th, 2025, which was the same day of your last hearing. And so it's really involuntarily.
Yes, ma'am.
And because it's actually true.
Yes.
So he never even made it.
I know. That's just screw it. I'm gonna do whatever I want because I already know I'm gonna get in trouble because you've been acting like an absolute fool in our jail. I'm not sure for. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? Showing yourself while masturbating to the female officers out there, don't you? You don't?
Ain't got no problem.
You don't have to know you're going to get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to. I'll hang on to it for now and then think about it. All right. So just for the record of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, but I can't not stick to my word. I told probation when you were here. I told you when you were here. No more incident. 1, 2, 3, 4, 5, 6, 7. Caught with a, looks like kind of a makeshift tattoo needle. We've got 4 or 5 at least times when you have been exposing yourself while masturbating to the office. Horse playing, smoking. I mean, it's just.
Judge, I certainly understand all these people in the jail.
No, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. I'm just reminding myself your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow simple rules. So I am going to, let's see. So I have documents here on this tablet that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Something wrong. Find you guilty of obstruction or retaliation, a third-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about 1.5 years, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right? You can go back with the bailiff.
Yeah.
A tense courtroom morning quickly spiraled into chaos as multiple defendants faced the harsh reality of their choices. Melissa Taylor entered court wearing a shirt with her son's picture, hoping for sympathy while struggling to hire a lawyer. But the atmosphere changed instantly when the judge ordered a drug test. Moments later, the results came back positive for methamphetamine, amphetamines, and ecstasy. The judge wasted no time, raising both of her bonds to $100,000 each, before deputies took her into custody right in front of the courtroom. Her emotional pleas about being a mother couldn't outweigh the failed drug test and repeated bond violations. Then came another shocking moment. A defendant previously released on bond after a competency ruling began arguing with the judge about medical evaluations and mental health treatment. After becoming disruptive and dismissive in court, the judge immediately revoked his bond, declaring him a danger to himself and the community. What began as a routine hearing turned into a dramatic reminder that courtroom behavior can instantly change someone's future. But the most intense moment belonged to Mr. Douglas, a man already given a second chance through probation. Instead of following rules, jail reports accused him of fighting inmates, exposing himself to female officers repeatedly, smoking contraband, and causing non-stop trouble behind bars. The judge openly admitted she regretted giving him another opportunity after reviewing pages of misconduct reports. In the end, she sentenced him to 4 years in prison, warning him that his own behavior would determine whether he ever sees parole early. By the close of court, one message stood above everything else. Second chances mean nothing without discipline. The judge made it clear that excuses, disrespect, and reckless behavior only push defendants deeper into consequences they can no longer